The truck arrived at 6:40 in the morning on a Thursday in April of 2007, and the man driving it did not knock on the door. He pulled directly into the equipment shed, hooked a chain to the front axle of the Massey Ferguson 6480 sitting in the first bay, and had it on the flatbed before Carl Brenner reached the shed door. Carl was 54 years old. He had been drinking his first cup of coffee when he heard the truck engine in the lot. He was still in his boots when he stepped outside and saw the 6480 going up the ramps. He said, "What are you doing?" The man on the flatbed said, "Repo order, first ag credit. You've got the paperwork inside." Carl said, "The payment isn't due until the 15th. The man said, "I don't handle the paperwork. Call the office." Carl said, "It's 6:40 in the morning." The man said, "Call when they open." The flatbed pulled out of his driveway with the Massey Ferguson 6480 on it at 6:52. Carl stood in the driveway and watched it go, and then went inside and sat at the kitchen table and looked at the calendar on the wall. It was April 9th. The payment on the equipment note was due April 15th. He was not late. He had not missed a payment. He had not received a default notice, a demand letter, or a phone call. His tractor was gone. He called First Ag Credit when the office opened at 8. He was connected to an account manager named Dennis Hartley, who explained that the repossession had been authorized under a cross-default clause in Carl's loan agreement, a clause that allowed First Ag Credit to accelerate all outstanding obligations if any single account under their portfolio showed signs of financial stress. Carl's farm operating line, which was a separate account from his equipment note, had been flagged by First Ag Credit's risk assessment system after Carl had requested a 30-day extension on his operating line payment the previous month. Carl said, "I asked for an extension. I didn't miss a payment." Dennis said, "The extension request triggered a risk flag. The risk assessment authorized acceleration." Carl said, "My equipment note payment is not due until the 15th. I have 6 days." Dennis said, "The cross-default clause applies to all accounts simultaneously." Carl said, "Nobody told me my extension request would trigger repossession of my tractor." Dennis said, "The cross-default provision is in your loan agreement. Page 14, Section 6, subsection C. It's April 9th. Planting starts in 11 days. Dennis said he understood the timing was unfortunate and that Carl was welcome to bring his account current and discuss a reinstatement of the equipment. Carl asked what bringing his account current meant in this context. Dennis said it meant paying the remaining balance on the equipment note, $61,400, plus the operating line balance and the reinstatement fee of $2,200. Carl said, "You want me to pay $63,000 in 6 days, or I don't get my tractor back for planting." Dennis said, "That is the reinstatement requirement, yes." Carl hung up. He sat at the kitchen table for a long time. Then he called his attorney. Carl Brenner had been farming 580 acres in Benton County, Indiana, since 1986. He had built the operation carefully across 21 years, buying land when the price was right, adding equipment when the need was real, maintaining what he had with the seriousness of a man who understood that an equipment failure during planting or harvest was not just a mechanical problem, but a financial one, with consequences that compounded across the season. The Massey Ferguson 6480 was his primary tractor. He had bought it in 2004, financed through First Ag Credit on a 7-year note at 6.4%. The payments had been consistent. He had not missed one. The equipment note was current to the day they took the machine. The operating line was a different matter. The 2006 growing season had been difficult, a wet spring that delayed planting by 9 days, a dry August that cut his corn yield 23% below projection. His operating line payment, due in February of 2007, had been tight. He had called First Ag Credit in January and asked for a 30-day extension to allow his grain marketing to catch up with his cash flow. The request was reasonable, routine, the kind of accommodation that agricultural lenders make routinely for farmers managing the specific cash flow patterns of a commodity business. First Ag Credit had granted the extension. Carl made the payment within 30 days. His operating line was current. His equipment note was current. By any reasonable measure, Carl Brenner's accounts were in good standing on the morning of April 9, 2007. What had happened, Carl's attorney explained that afternoon, was that the extension request had been entered into First Ag Credit's automated risk management system as a distress indicator. The system flagged Carl's portfolio as elevated risk. It then applied the cross-default clause and authorized acceleration without human review. The repossession had been ordered by algorithm and executed by a contractor who did not know the account history and was not required to know it. Carl's attorney said, "This is going to be a problem for them." Carl said, "It's a problem for me right now. I have 11 days until planting." His attorney said, "Yes, we're going to address both." The attorney's name was Margaret Holloway. She had been practicing agricultural law in Lafayette for 19 years and had handled equipment repossession cases before, but not one with this specific fact pattern. A borrower current on all obligations, who had been granted an extension he subsequently fulfilled, whose tractor had been repossessed by automated system under a cross-default clause, never triggered by any actual default. She filed for an emergency temporary restraining order on the morning of April 10th. The motion argued that First Ag Credit had breached its implied covenant of good faith and fair dealing by applying the cross-default clause to a non-defaulting account, that the automated repossession without human review or notice violated the Indiana Uniform Commercial Code's requirements for commercially reasonable repossession procedures, and that Carl Brenner was suffering irreparable harm in the form of lost planting days for which no monetary compensation could be fully adequate. The circuit court judge heard the motion on April 11th. The judge granted the temporary restraining order on April 12th. First Ag Credit was ordered to return the Massey Ferguson 6480 to Carl Brenner's property within 24 hours. The machine was back in his shed on the evening of April 13th, 4 days after it had been taken, 7 days before his original planting target. Carl had lost 4 planting days. He adjusted his field schedule, prioritized his best corn ground, and compressed the work into longer days. He documented everything. The temporary restraining order was the beginning, not the end. Margaret Holloway filed suit against First Ag Credit in May of 2007, after the planting was complete and the full scope of the damage could be assessed. The complaint alleged 4 causes of action: breach of contract, breach of the implied covenant of good faith and fair dealing, wrongful repossession under the Indiana Uniform Commercial Code, and conversion, the civil tort of wrongfully taking another person's property. First Ag Credit's initial response was to deny liability on all counts and to file a motion to dismiss, arguing that the cross-default clause unambiguously permitted acceleration in the circumstances that had occurred. The motion to dismiss was denied in August of 2007. The court held that the question of whether the cross-default clause had been triggered by circumstances that constituted commercially reasonable grounds for acceleration was a factual question that could not be resolved on a motion to dismiss. Discovery began in the fall of 2007 and produced, over the following 8 months, a document record that Margaret Holloway later described as the most useful discovery she had ever received in 19 years of agricultural litigation. The documents showed that First Ag Credit's automated risk system had flagged Carl's account based on a single input, the extension request, without considering any other factor in the account's history. They showed that the system had then generated a repossession order without any human review. They showed that First Ag Credit had a written internal policy requiring human review of all repossession authorizations above $50,000, a policy that had not been followed in Carl's case because the automation had routed the order directly to the repossession contractor without passing through the review queue. They showed something else. In the 18 months prior to Carl's repossession, First Ag Credit's automated system had triggered 14 similar cross-default accelerations across Indiana and Illinois, all of them involving farmers who had requested routine extensions and subsequently fulfilled their obligations. In 11 of the 14 cases, the farmers had not had the resources to challenge the repossession and had surrendered their equipment. In 2 cases, the farmers had reached private settlements. Carl's was the third case to reach litigation. Margaret added a class action component to the complaint in March of 2008. The trial began in September of 2009, 2.5 years after the morning the flatbed arrived in Carl's driveway. The case had attracted attention in the agricultural community in a way that legal cases rarely do, not through media coverage, which was limited, but through the specific communication channels of farming communities, where a story about a lender taking a farmer's tractor on planting week based on an automated risk flag travels with the velocity and fidelity of something that everyone who hears it recognizes as directly relevant to their own situation. Carl had received calls from farmers he didn't know in counties he had never visited, asking about the case, sharing their own stories of First Ag Credit's repossession practices, some of which matched the pattern in the documents Margaret's discovery had produced. At trial, First Ag Credit's defense rested on two arguments. First, that the cross-default clause was unambiguous and that Carl had signed the agreement containing it. Second, that the automated repossession system, while it had not followed the internal review policy, had functioned as designed and that the design was commercially reasonable. Margaret's case rested on three things. The account history. Carl Brenner was current on all obligations on the morning his tractor was taken. The extension he had requested had been granted. He had fulfilled it within the 30 days. There was no default. There had never been a default. The algorithm had repossessed a machine from a borrower who owed nothing past due, based on a risk flag generated by a request that had been resolved months before the flatbed arrived. The internal policy violation. First Ag Credit's own written policy required human review of all cross-default acceleration decisions above $50,000. The policy existed because someone inside the company had understood, at the time it was written, that automated systems cannot read the full context of an account relationship. That person had been right. The policy had been bypassed because the automation routed the order directly to the repossession contractor without passing through the review queue. A person who had looked at Carl's account history, current payments, fulfilled extension, no delinquency, would have stopped the order. The system had not given any person that opportunity. The pattern. 14 similar cases across 18 months. 11 farmers who had surrendered their equipment without the resources to challenge. 2 private settlements. Carl's case was the third to reach a courtroom, and it was reaching that courtroom with documentation of the other 13 in the discovery record, which meant the jury was not looking at an isolated error. They were looking at a practice. The jury deliberated for 3 days. On the 4th day, they returned a verdict for Carl Brenner on all 4 counts. Actual damages were assessed at $480,000, covering the yield loss from the 4 displaced planting days across 2 growing seasons. The cost of emergency equipment rental during the 4 days without the tractor, the documented stress and management disruption, and the legal costs of the restraining order and subsequent litigation. Punitive damages were assessed at $1,620,000, based on the jury's finding that First Ag Credit's conduct had been willful and systematic, not an error but a practice, applied across 14 accounts, that had been insulated from correction by the automation that removed human judgment from the decision. Total verdict, $2,100,000. Carl Brenner sat in the courtroom when the verdict was read and did not immediately respond. He had been in this proceeding for 2.5 years. He had farmed through it, planting and harvesting, while the depositions were taken and the motions were filed and the discovery documents filled Margaret Holloway's office with the evidence of what First Ag Credit's system had done to 14 farmers in 2 states. He had done the accounting every season, updating the damage calculation with each harvest, keeping the records that Margaret's case required. He looked at the number, $2,100,000, and felt something that was not quite satisfaction and not quite relief, but the specific resolution of something that had been unresolved for a long time. The tractor had come back, the planting had happened, the farm had survived. The case had confirmed what Carl had known on the morning of April 9, 2007, when he stood in his driveway in his boots with his coffee going cold inside, and watched his tractor go up the ramps of a flatbed that had not knocked on his door. What had happened was wrong. Not wrong in the abstract, but wrong in the specific and measurable way that a court had now documented in a verdict that carried a number. $2,100,000 was that number. First Ag Credit appealed. The appeals process extended the case through 2011. The appellate court upheld the verdict on the breach of good faith and wrongful repossession counts and reduced the punitive damages from $1,620,000 to $1,200,000, citing proportionality standards for punitive awards in commercial cases. The total award after appeal was $1,680,000. First Ag Credit paid in February of 2012, nearly 5 years after the flatbed left Carl's driveway with the 6480. The class action component of the original complaint had been severed from Carl's individual case and proceeded separately. It was settled in 2013 for an undisclosed amount that covered the 11 farmers who had lost equipment without the resources to challenge the repossession and had not received it back. The settlement required First Ag Credit to revise its automated risk management system to require human review of all cross-default acceleration decisions and to provide written notice to borrowers before any repossession action was taken. Margaret Holloway said when the settlement was announced that the policy changes were more significant than the money. She said that the practice that had been applied to Carl and to 14 other farmers had been insulated from correction precisely because the automation had removed the human moment at which the error could have been caught. The settlement restored that moment. It required a person to look at an account before a truck was sent to take a machine. Carl was 59 years old when the settlement was announced. He had been farming for 27 years. He still had the Massey Ferguson 6480. It had crossed 12,000 hours by then. He maintained it the way he had always maintained it. Oil every 100 hours, filters on schedule, pre-season inspections in March before the ground was ready to work. In March of 2013, doing the pre-season inspection, he found wear in the hydraulic pump that the hour meter and the maintenance schedule said was expected at 12,000 hours. He ordered the rebuild kit. He pulled the pump on a Saturday morning and rebuilt it over 2 days, following the service manual the way he had always followed it. He started the engine on a Monday. It ran clean. The hydraulics were full pressure. The tractor was ready for the season. He noted the hydraulic pump rebuild in his maintenance log. He noted the date and the hour count and the parts used and the cost. He closed the log and put it back on the shelf where it had lived since 2004. Carl Brenner still farms 580 acres in Benton County. He is 71 years old. The Massey Ferguson 6480 is still in his equipment shed. It has 16,000 hours on it. The hydraulic pump has been rebuilt twice. The engine has never been opened beyond routine maintenance. His son Thomas joined the operation in 2015. Thomas had been working in agricultural finance in Indianapolis, a career choice that Carl had never discouraged and never pushed toward, because the farm was something you came back to when you understood what it was and not before. Thomas came back in 2015 because he understood what it was. He had watched his father farm through a lawsuit and a harvest simultaneously and understood from that observation that the farm was the thing and that everything else was in service of the thing. Thomas asked his father once what the lawsuit had really cost. Not the legal fees, not the yield loss. Those were numbers the verdict had covered. What had it actually cost? Carl said 4 days in April of 2007, when I didn't know if the planning was going to happen. That's what it cost. The rest was accounting. Thomas said, and the 2.5 years of litigation? That was the price of the accounting being correct. It needed to be done. But the cost was those 4 days. The 4 days when the tractor was gone and the planting window was moving, and the algorithm that had taken the machine had no idea what April meant to a farmer in Benton County. That was the cost, not the money. The verdict had addressed the money. Nothing had addressed the 4 days except the judgment Carl had carried since the morning he stood in his driveway watching the flatbed leave, that what had happened was wrong, and that the wrongness had been worth documenting, and that documenting it correctly had taken 2.5 years and had been worth every one of them. On the wall of his farm office, framed, is the cover page of the jury verdict from September of 2009. Not as a monument to the money was what the damage required, nothing more, but as a document of what had happened on a Thursday morning in April of 2007 and what the accounting of that morning had eventually produced. Below the verdict, on the same wall, is the payment confirmation from First Ag Credit dated February of 2012. Carl put it there because it completed the record. The morning of April 9th, the verdict of September 2009, the payment of February 2012. 3 documents, 3 dates, the beginning and middle and end of a thing that had cost him 2.5 years of litigation, alongside 2.5 years of farming. He had not stopped farming during the litigation. That had not been an option, and it would not have been his choice even if it had been. The farm was the thing. The litigation was necessary but secondary, the mechanism by which a wrong was corrected, not the point of the correction. The point of the correction was the account history that showed Carl Brenner had not defaulted, the extension request that had been granted and honored, the equipment note that had been current on the morning a contractor hooked a chain to his front axle without knocking on his door. The Massey Ferguson 6480 is still in the shed. Carl starts it every spring the same way he started it before April of 2007, and the same way he started it after. Key in, throttle up, engine finding its idle in the way that a well-maintained diesel finds its idle, without drama and without complaint, the way any machine runs when it has been treated correctly across a long time. He does his pre-season inspection every March. He notes everything in the maintenance log. He plans the season from what the log and the fields and the calendar tell him. On April 9th of every year, he notes the date in his farm journal, not with extended commentary, just the date and one line. Tractor came back. It is the only entry he has made on that date since 2008 when he started the practice, and it will be the only entry he makes on that date for as long as he is farming. The tractor came back. The harvest happened. The court said what the morning had already said. $2,100,000 was the number. 16,000 hours is the current count. And the Massey Ferguson 6480 is in the shed, ready for another season. The same machine that a flatbed took at 6:52 in the morning on a Thursday in April, and brought back 4 days later because a judge had read the account history and understood what the algorithm had not. The season starts when the ground is ready. It always does. It always will.